Hey class, Mr. Stewart here. This is going to be the integrity video for Chapter 15 for CRJ 146, and today I'm going to be talking about obtaining evidence from computers, search warrants, wiretapping, or canines. It's kind of what this chapter. It's kind of a catch-all of some various and sundry ways of obtaining evidence. So I'm going to be skipping around a little bit and kind of. This lecture is going to seem probably a little bit scattered, simply because this chapter is also a bit scattered as well. So, as far as computers go, that is becoming probably one of the most fertile grounds right now for obtaining evidence in many criminal investigations, because it's something that most people either have a desktop computer, a laptop computer, a tablet, or a smartphone, which in essence is simply just a small tablet these days. So, and many of you even do your work on your online classes via those devices. Criminals will also use those devices to perpetrate their crimes, and they may be storing information on those, especially the mobile devices that you may need to acquire in order to successfully prosecute a particular case. So just understand that a computer is not something that, unless it is a public computer in a public library, if it belongs to somebody, they have a legitimate expectation of privacy within that particular device, and therefore it is subject to the Fourth Amendment in regard to searches and seizures. Understand that the plain view doctrine will allow law enforcement to seize evidence of a crime if they see it in plain view. And what we mean is, if you are on a computer in a public library, or if you happen to be on one of the computers in the cyber cafe here on the Huntsville campus of Calhoun, and somebody walks by and they see you doing something you should not, or looking at something you should not look at, you have no legitimate expectation of privacy there. But if you're in your home, or you're sitting at the bus stop and you're doing something on your phone, you do have a legitimate expectation of privacy. However, if somebody is able to see from the public view what you're doing, then that could potentially be enough evidence in order to get a search warrant in order to continue looking through that device. If they see something that is immediately recognizable as illegal activity, and it's a law enforcement officer, they could immediately seize it and potentially hold you in custody. However, they could not continue to look through that device without obtaining a search warrant. So most courts have held that the warrants for computers should be pretty narrowly tailored to look for the things that may be described in the warrant. The interesting part about computers, though, and some of you who are taking this class, you may be computer gurus, and you'll understand this, is that if you're good with a computer, you can potentially hide whatever you want to hide under a different file extension, in something else completely different than what it appears to be. You can use steganography, which is basically hiding information in images. Terrorists have been using that for several years. So just understand that when you do obtain a warrant for a computer for specific evidence, it's probably going to give you the ability to look anywhere in that computer for that particular evidence, to make sure that that you're not missing it. The court identified some guidelines for issuance of computer search warrants, including the segregation and redaction of all seized files in order to turn over only what is in the request for the warrant, or the government search protocol must be stated in the warrant. Warrants must disclose any risk that information may be destroyed during the search, and the government must destroy or return to the owner, if legal, any non-responsive information discovered in the files. So if you get a search warrant and basically you're asking some entity to perform the search for you, like let's say it's a corporate computer, and you tell them exactly what you're looking for, they have the right to give you only what you ask for. They don't have to give you the whole computer. Typically, if you are, as a law enforcement officer, performing the search yourself, you have the right to take the computer, do the search on the computer. This is with a warrant, and then you must return any files unrelated to the crime, just because that doesn't have anything to do with that case. So just keep that in mind. Obtaining evidence from the internet. This is also something that is very common these days. People are engaging in crimes over the internet, cyber crimes, cyber hacking. That's kind of been replaced with the term high-tech crimes now. So we can see a lot of these may include crimes against children, abductions, pornography. All of those are typically done via the internet, so there's typically going to be some sort of trail left. If you can find one morsel or one end of that trail, you can typically trace it at least back to one or more of its roots. Typically the federal government and local governments have combined, and they have developed task forces in order to combat especially the child pornography and the sex trafficking and that type of thing. That's done via the internet. But if you happen to be involved in one of those investigations, just understand that it may very well be national in scope, cross state lines, and it's probably going to have to be done. Any searches and seizures are probably going to have to be done at the federal level, just to make sure that the I's are dotted and the T's are crossed. You also get evidence from other types of devices, laptops, cell phones, people don't really use pagers anymore. Personal data assistants, people don't really use those anymore. Everybody's kind of gone to a smartphone or an iPad or a tablet type of thing, and that's really what the current state of computer forensics is. It's with mobile devices. We're not doing a whole lot of computer forensics with desktop computers anymore, because most people have gone to these mobile devices as the means to perpetrate whatever crimes that they're doing. So just understand that law enforcement can obtain access to these devices with a search warrant based on probable cause or with consent. Just understand that, as I've mentioned before, with consent, that terms may be placed upon the consent, and you might not get what you want without the search warrant. Many courts have also held these devices may be searched under the search indictment to a lawful arrest exception. And these searches must be reasonable. For example, let's say you get arrested for selling drugs, and you made contact with the informant or the undercover officer via your cell phone. They can probably seize that cell phone at the time of your arrest and search that cell phone incident to the arrest. Just to make sure that they're not going to immediately lose some sort of evidence of the transaction at that point. Now, if they discover evidence of other crimes, they may have to get a warrant. They may have to. And like I've always said this, when in doubt, get a search warrant, because I would hate to make a really good case and then have all the evidence of that case thrown out because I should have got a search warrant and I didn't, or I could have and I didn't. So when in doubt, always obtain a search warrant if possible. Search warrants in general fall under the Fourth Amendment, in which case the minimum amount of proof necessary to obtain a search warrant is probable cause. Those are those specific and articulable facts that would lead a reasonable person to believe a crime has been, is being, or is about to be committed. That's the gold standard. You have to have that probable cause quantum of proof in order to obtain a search warrant. Basically, you have to fill out an affidavit that is in support of the search warrant itself, and that affidavit is what will have the probable cause on it. That affidavit must be facially valid, which means it must be able to stand alone as your probable cause statement. And then once a judge has signed off on your affidavit, then they will issue the search warrant, and that basically is a court order based upon the affidavit where the court is ordering you to go to a location and search for some very specific things to be seized. There's also time limits on it. Once you get a search warrant, you have certain time limits that it has to be executed by. And then you have another time limit that you have to return it to the court, along with a list of everything that you seized under the search warrant. So it's not as easy or as quick as TV would like you to believe. In most places, you just simply can't make a phone call and get a search warrant either. You're going to have to sit down, write out the probable cause statement in an affidavit form, take that to a judge. He's going to get you to swear to it. If he agrees with it, he's going to sign it, and then you're going to fill out a search warrant, and the judge is going to ask you to swear to that, and then the judge will sign it, and when he signs it, it is considered to be issued at that point, and then that's when the clock starts. Is basically have a certain amount of time to serve and execute that search warrant, and then a certain amount of time to get that search warrant along with a list of whatever you seize back to the court. Any discrepancy in any of those things, the search warrant and whatever you found during the warrant could potentially be thrown out of court, and you would not be able to use that evidence. So basically your I's have to be dotted and your T's have to be crossed when you get a search warrant. Grove versus Ramirez is a case that talks about the particularity and the specificity requirements of the search warrant. It says the search warrant needs to state with particularity the place to be searched and the items to be seized. The fact that the affidavit specified the items to be seized did not save a search warrant from being facially invalid. You have to not only specify exactly what you're looking for, you have to really specifically and particularly describe where you're going to go to serve the search warrant at. You should be able to give that search warrant to any law enforcement officer, and they should be able to locate the residence or the business or wherever the location is. They should be able to find it without any problem. There should be no question in their mind that they're in the right place based upon the description in the affidavit and the search warrant. I mean, when I have written search warrants in the past, it's been so specific that I describe the color of the shingles, the color of the siding of the house, the color of the shutters, if it had shutters, if it had a fence, specific artwork on a mailbox, or specific items in a yard, what the houses on either side looked like, what the numerical address was and where it was located on the house or the mailbox, so that anybody could take that and they could look at the directions and the specificity within the warrant, and they would know without a shadow of a doubt that they were in the right location. What you don't want to do is to get a search warrant and then you let's say you come up sick and you can't go serve it, and so somebody else goes and serves it and they hit the wrong house, and let's say in the course of executing the search warrant on the wrong house, let's say either a police officer is shot and killed, or possibly even an innocent civilian is shot and killed, and all of that could have been avoided if the search warrant was written correctly. So keep that in mind. That's not something you want on your conscience, and that has happened in the past. And it happened up the road from Huntsville up in Gallatin, Tennessee, several years ago when a SWAT team served a search warrant. There was a problem with the specificity in the warrant. It was a duplex. They hit the wrong apartment of the duplex. Elderly gentleman inside the residence thought somebody was breaking in his house. He didn't see or hear very well, so he got his shotgun, started down the hallway in the dark. SWAT team met him in the hallway. All they saw was him with a gun, and they shot him and killed him. So, bad things can happen if you don't follow the rules when obtaining search warrants. Payton versus U.S. is another interesting case. The Supreme Court held that a search inside a residence is presumptively unreasonable without a warrant or under an established exception. to the warrant requirement. So you cannot search somebody's house unless it is either an emergency situation where exigent circumstances exist, excuse me, consent is given, or you have a warrant. You can't simply force your way in and search somebody's house without one of those three conditions being met. Keep that in mind. There are different types of search warrants. Your book talks about these. Read over those. There are some interesting idiosyncrasies with the different types of search warrants. So I'm not going to get into that here in this lecture, but it's pretty straightforward. Make sure you read over that. And I'm going to move on here. Talk about wiretapping for just a minute. Many people also believe that it's really easy to bug somebody's phone or to intercept their emails or their cell phone calls. It can be done. It is not something that is done by local law enforcement on a regular basis. And in fact, local law enforcement have to go through a federal judge in order to get the search warrant in order to do that. It's based upon a 1968 act that Congress enacted called the Federal Wiretapping and Electronic Surveillance Act. Most states also follow by enacting similar state laws. Basically what it says is that if you want to intercept somebody's phone calls, bug their phone, bug their house, intercept their emails, etc., 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 as part of an investigation, you're going to have to go through a federal judge, and they're going to have to give the authorization. Now, it was fairly difficult, and you had to really know exactly what you were looking for and have some good probable cause prior to 9/11 before this happened. Unfortunately, after 9/11, with the passage of the Patriot Act, it made this part of criminal investigation much easier for law enforcement, which basically that is, if we can attribute that somebody is a threat to national security, we can now just call our supervisor, and our supervisor can give us the okay in order to initiate electronic surveillance of somebody, which basically means without a search warrant. And they kind of worry about getting the warrant later if they get something that they can use. So it's kind of a gray area. Many people believe that it's unconstitutional, and I tend to agree with it. That national security probably shouldn't trump individual rights for the most part, because yes, it would allow us to catch the bad people, but how long before, and this becomes a slippery slope, that instead of just using these expanded powers to catch the bad people, we're also spying on the good people too. And many people say, well, if I'm not doing nothing wrong, it doesn't matter. It does matter, because you have an expectation of privacy. You have a right to privacy under our Constitution. So keep that in mind too. This is kind of a controversial issue, especially after the Patriot Act. Okay. This act allowed federal and state laws to authorize court orders permitting wiretapping or electronic surveillance by law enforcement officers like a search warrant. The act of conducting wiretapping or electronic surveillance in violation of the act became a felony. So basically, if you did it wrong, the police officer could be charged with a felony. So that's why they take steps to make sure that this is done correctly. So keep that in mind as well. You can read over in your text where it talks about thermal imaging devices. In this particular case, Kylo versus U.S. Obtaining evidence from tracking devices. GPS device, like placing GPS devices on vehicles or something. You can do it. This is an interesting case here. It says in December 2006, the federal rules of criminal procedure were revised on procedures for the installation and use of a GPS device. The court held that the attachment of a GPS device to a vehicle on public roads is not a search and thus did not require a warrant. However, a warrant is required when the car is parked in a private garage or in a driveway. So basically, if you have a target vehicle and you want to follow them around or you want to see where they're going, you could potentially attach a GPS device to their vehicle as long as it's not on private property when you put it on. But you cannot go on private property and put it on unless you have a search warrant. If you have a search warrant, then you can. Again, it's not something that's used that frequently, but it can be used if necessary. UTEX also goes in and talks about some of these other electronic surveillance devices. We still use a lot of these today. Again, the book talks about them. This is kind of a catch-all chapter. It's not something you may use that frequently. Again, what we're doing is computer forensics and mobile computer forensics right now. Let's see, situations where court orders are not required. Any type of overheard conversation. You hear somebody talking about something in the public, no search warrant or court orders required in order to use that. Statements made to an undercover officer or others in their presence. No court orders required for that. Tape recordings where suspect has no expectation of privacy, such as in jailhouse telephone calls. Know that those are recorded and people are listening to those. In the back seat of a police car, I used to have a micro cassette recorder that I had attached in my police car with a microphone that I had ran all the way to the back seat. And that way, if I happen to have arrested a couple people and put them both in the back of my police car, then and they may want to talk about where something may be hidden in the car or whatnot, I could catch that on tape. When I put them in the car, I'd start the tape, and it worked really good. And they have no expectation of privacy when they're under arrest in the back seat of a police car. One party to a telephone conversation consents to recording or listening to conversation by police. Basically, you can record phone calls with people as long as one party knows about it. So, if you want to record your phone call with somebody, it's no problem because you know about it. And you do not have to tell the other party. Where you get into trouble is if you start, we have seen husbands try to, in fact, I had a friend that did this. He set up a recording device underneath his house on the phone lines because he thought his wife was cheating on him. So he was recording her phone calls with other people, and he wasn't real good at it. She caught him, and it was a big blow up, and they ended up getting divorced and all this kind of stuff. That's probably where it was going anyway. But that was actually illegal. You can't do that. If he wanted to record his phone calls with her to use against her in court, that's fine, and she could have done the same thing. But without a search warrant, you cannot record phone calls where neither party knows that they're being recorded. Using body wires, radio transmitters, we do that in undercover a lot. That's no problem. Confrontational telephone calls requires cooperation of a witness or a victim, and the call has to be placed before criminal charges have been filed. So basically, let's say you have a victim or a witness or somebody that's willing to make a phone call and try to get somebody to come clean about what they've done via the conversation, then as long as no charges have been filed, no problem has arisen there. If the call is after charges have been filed, it's accusatory, and it is designed to elicit an incriminating statement, and they would have to be given their Miranda rights before you could do it. But if no charges have yet been filed, you can have anybody that wants to make a phone call and that are cooperating with the police and try to get them to elicit incriminating information. Dogs. Read over the section in your book. It's real straightforward in regard to canines, and just understand that the canines are typically considered reliable. They're alerts on cars on the side of the road for drugs or in a location for explosives or are considered probable cause and would either allow you to obtain a search warrant or go ahead and perform the search depending upon where the location is. Running a dog around the car, it does not require a warrant or probable cause. That's called the free air doctrine. A canine sniff around the outside of a car does not require a search warrant, nor does it require probable cause. You can just do it as a general part of a car stop. Now, if they alert, that alert is now probable cause, and you can search that vehicle under the Carroll doctrine without the having to go get a search warrant. Now, if a dog alerts, let's say on a residence, then you have to go get a search warrant or get consent to search that residence. All right, so you can read over this particular court case as well. Just basically says the same thing that I just said. Factors that affect the dog's reliability: their training, their success rate, the method used to train the dog. That's why police canines are so expensive, because number one, you're buying a really good quality dog. Number two, they have been trained by people who have the correct certifications and tools to effectively train those dogs. And so, in essence, when they sell you a police dog for $15,000 or $20,000, you're not only buying the dog, you're buying basically the credibility of the trainers and every dog that they trained prior to that point, because you can go back and you can say, if they want to question the effectiveness of your dog, you can say it was trained by this particular group of people or this particular company, and here's what they've done in the past, yada 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 yada. And then you also keep up with every search your dog performs in order to see what the success rate of your dog is, and any retraining that's given to the dog over the dog's career. All that would be used to determine the dog's reliability for each individual case. And basically all that's just everything I just said. So that's pretty much it for this chapter. It's kind of a catch-all chapter, some pretty interesting material. So if you have questions, reach out. I'll be grading the last couple of weeks here, probably last part of this week or first part of next week. And if you have questions, reach out, and I'll see you soon. Bye-bye.